Hello friends, I'm Sanjay. This is part 4 of the series where I'm covering the interpretation of statutes and the principles of legislation as per the standard LLB syllabus. We have previously covered all the internal aids to interpretation of statutes, which are essentially the various parts of a statute, and also various external aids to interpretation. In this part, we will cover 5 more external aids to interpretation which are a little different. Though there is no official name for this group, we can call them multi-factor external aids for the sake of convenience. We can call them multi-factor because they actually use multiple external aids to interpretation. For example, Travaux Préparatoires may consist of the historical background, previous laws, legislative history, parliamentary debates, and references to the Constitution. Law Commission reports will include the historical background, previous laws, judicial interpretations, legislative history, etc. Inquiry Commission reports not only provide an in-depth review of the specific incident or situation, they may also discuss how various statutes can be applied to the case on hand and also discuss relevant judicial interpretations. In short, the 5 external aids that we will cover in this video mainly use other external aids that we have previously discussed. Travaux Préparatoires is a French term that simply means preparatory works. This term is mainly used in the context of international treaties. It simply means that when interpreting an international statute or a treaty, we should look at the negotiating history, the drafting history, and any reference documents that were used during the drafting and the discussions about the treaty. These are nothing but the preparatory works done before the treaty was signed and agreed. Article 32 of the Vienna Convention on the Law of Treaties talks about supplementary means of interpretation. It says that if the plain language of a treaty is ambiguous or obscure, or if the normal interpretation of a treaty based on its plain words is leading to an absurd or unreasonable meaning, then supplementary means of interpretation, including preparatory works of the treaty, can be used for interpretation. As I mentioned earlier, this preparatory work is nothing but Travaux Préparatoires. Pari Materia means on the same subject or matter. So, statutes in Pari Materia means statutes that cover the same subject or same matter. For example, the Indian Contract Act and the Sale of Goods Act both deal with contracts. So, at a higher level, they have the same subject. The Code of Criminal Procedure and the Indian Evidence Act both deal with criminal law and procedure. So, at a higher level, both of them have the same subject. A point to remember here is that if we go into the specific details, then these statutes address different aspects of the same subject. While the Indian Contract Act covers a wider range of contracts, the Sale of Goods Act is more focused on contractual transactions associated with the sale of goods. The basic idea behind the principle of statutes in Pari Materia is that if there are 2 statutes covering the same or similar subject matter, then they should be interpreted in the same or similar manner. For example, you cannot have one rule for general contracts under the Contract Act and another rule for contracts under the Sale of Goods Act. Otherwise, there will be contradiction and confusion. So, statutes covering the same or similar subject should be interpreted in the same or similar manner. To identify statutes in Pari Materia, the Delhi High Court specified some tests in its decision in the Rais-uz-Zama versus State of Delhi case. It said that if 2 or more statutes have been given a collective title, like criminal laws or contract laws, then it signifies that the set of statutes are in Pari Materia. Or if 2 statutes have to be construed as one. For example, the Companies Act and the Companies Amendments Acts have to be construed as one act. Then such acts are in Pari Materia. Acts having short titles that are identical, apart from the calendar year. For example, the Finance Act 2020, the Finance Act 2021, 2022, 23, all of these have identical titles except for the year, which means that these statutes are in Pari Materia. Even the Companies Act 1956 and the Companies Act 2013 are statutes in Pari Materia since they have the same title but different years. Different acts that deal with the same subject matter on the same lines, for example, the Industrial Disputes Act and the Trade Unions Act, both relate to labor relations and workers' rights. Both contribute to the framework governing industrial relations. Therefore, they are statutes in Pari Materia. The Sale of Goods Act and the Consumer Protection Act both deal with the rights of buyers and sellers and warranties and other conditions regarding goods. Both acts are designed to protect the interests of the buyers and sellers in the marketplace. Therefore, they are in Pari Materia. With regards to how to use this principle of statutes in Pari Materia in interpretation, the Supreme Court has provided clarifications in various decisions. Two statutes dealing with the same subject matter must be interpreted harmoniously. The language of one statute can be clarified by referring to the other statute in Pari Materia. And the doctrine of Pari Materia applies even when the statutes are not in Pari Materia in every respect, that is, they are not exactly same. India has many laws that were originally enacted during the British Raj in 1836, 1842, 1850, and many of these statutes are still valid, even though they are more than 150 years old. Contemporanea Expositio is a principle of interpretation that is useful in situations where the court is dealing with such very old laws. This term is a Latin phrase which means contemporary exposition. The basic idea here is to interpret a statute by understanding the social, historical, and linguistic context in which the law was created. That is, we have to look at the contemporary factors when the law was originally created. This will help us understand the legislative intent behind the law and why it was created. For example, if there is an old law which says that the speed limit for vehicles in a particular area is 20 km per hour. When we look at the contemporary situation when the law was enacted, it could be that there were no motor cars at that time. The term vehicles in that old law referred to horse-drawn carriages. Or if the rules for an exam say that no calculators allowed, and these days people don't use calculators much at all since we use smartphones. So if we try to implement the rule as is, it will lead to an absurd situation where calculators are not allowed but phones are allowed, which are more powerful than calculators. By looking at the contemporary situation when the law was created, we can understand its original intent. What was the mischief that the law addressed? The court can then decide whether the law is currently relevant or not, and how the law can be enforced in the current situation, and what are the changes that may be required to make the law suitable for the current society. In some landmark cases, the court has emphasized that when interpreting old laws, the state of affairs prevalent when the law was enacted should be taken into consideration, and also that this principle is more of a guidance and not a rule. If the words of a statute are clear and unambiguous, then it should be enforced as is. If you go to the Ministry of Home Affairs website, you will see that there is a section containing reports by various judicial commissions or inquiry commissions. These commissions are appointed by the government or by the courts when there is a need for a thorough and independent investigation into a specific serious issue or event, especially those which affect the interests of the wider public. For example, there is a report here by an inquiry commission looking into the issue of illegal mining in the state of Jharkhand. If a court is dealing with this specific case, then the inquiry report provides a better understanding of the situation where the statute needs to be interpreted. For example, when the Bhopal gas leak happened, it was one of the world's largest industrial accidents, and probably none of the laws that existed at that time were designed to deal with such a situation. So, in the cases involving Union Carbide, the Inquiry Commission reports provided a better understanding of what actually happened and how people were affected in the short term and in the long term. That way, the Inquiry Commission reports help the courts in interpreting the law to deal with this unprecedented situation. Similarly, in the 2G spectrum case, the Inquiry Commission reports provided clarity on what the issue was all about, how are the procedures and policies violated, and how the laws need to be interpreted to address the situation related to telecom licensing. The Law Commission of India is a non-statutory body that is constituted by the Government of India under the aegis of the Ministry of Law and Justice. The Law Commission primarily conducts research on various topics in the field of law, and the Commission makes recommendations to the government. These recommendations may be for creating new laws, for amending existing laws, for scrapping old laws, or for reviewing the interpretation of various laws. The normal tenure of the Law Commission is 3 years, and during this period, they can submit several reports on various topics. You can find all the Law Commission reports on their official website. For example, this report number 274 was one of the 15 reports published by the 21st Law Commission. And this report is a review of Section 2 of the Contempt of Courts Act. If you look at the contents of the Law Commission Report number 274, it is a very elaborate and comprehensive document. It starts with the history of the concept of contempt of court in India. It looks at the existing provisions which address this mischief. What is the international scenario? What has been the judicial approach on contempt? What is criminal contempt? What does not amount to contempt? And the conclusions and recommendations that can be drawn on the basis of all of these. These recommendations may have led to changes in the policies or procedures or even changes to the law itself. When a court has to interpret a statute to deal with a situation involving a contempt of the court, these Law Commission reports provide a comprehensive background on the topic and the associated statutes. In the Aadhaar case, the court referred to multiple Law Commission reports that touched upon the privacy implications of Aadhaar. In the Triple Talaq case, the court referred to reports that focused on family law reform. In the Vishaka Guidelines case, the court referred to the 84th report that addressed the key issue of the case. Another interesting aspect is that over the years, several Law Commission reports have covered topics related to interpretation of statutes as well, such as the need for clarity while drafting laws, the usage of legislative history as an aid in interpretation, the basic principles of interpretation, the importance of considering the original context and purpose behind a statute, the usage of the General Clauses Act for interpretation, and interpretation issues in the context of evidentiary laws. Therefore, we can conclude that Law Commission reports are a very important external aid to statutory interpretation. And with that, we have come to the end of this part. If you have any questions or feedback, post a comment below. Thank you in advance for your like, share and subscription. We will meet again in the next video. Take care and stay safe.